Good morning, class. Settle down, please. Let's have pin drop silence. Before we dive into today's explainer of the source material, I need to explicitly address a glaring clerical error in the syllabus handout you got this morning. It incorrectly prints the heading as Q26 Distinguished Contract of Indemnity and Guarantee. I'm telling you right now, take your pens, strike that out, and ignore that typo completely. The literature we are actually dealing with today is on the board. Remedies for breach under the Sale of Goods Act 1930. This is a highly scoring area if you just apply yourselves properly. So put your textbooks away and let's focus entirely on mastering this statute. Here is the exact blueprint for today. 1. Introduction to legal remedies. 2. Part I. Remedies available to seller. 3. Part 2. Remedies available to buyer. 4. Common remedies and damages. 5. Landmark case law analysis. And 6. Conclusion for examiner evaluation. Now I instruct you to meticulously draw this exact synopsis block on page 1 of your answer scripts for a 16-mark question. Don't skip it because university evaluators absolutely expect this blueprint. Let's start with Section 1, Introduction to Legal Remedies. You need a strong foundation to immediately capture the evaluator's respect. Read what's on the board. When a contract of sale is breached, both parties are entitled to legal remedies. These remedies are provided under the Sale of Goods Act 1930. Now, why start here? By establishing this statutory authority immediately, you secure your baseline marks from the evaluator. You're telling them, I know the exact source of this law. It firmly grounds everything else you're going to argue in the specific parameters of the 1930 Act. Moving on to Section 2, Part I, Remedies Available to Seller. When you write this heading in your exam papers, I command you to underline it twice. Make it stand out. Let's read the exact text. 2. Suit for price, Section 55, property in goods has passed, and buyer fails to pay. 3. Damages for non-acceptance, Section 56, when buyer refuses to accept goods, seller can claim compensation for loss. Listen carefully. We need to deliberately break down these strict legal conditions. Look closely at Section 55. The property in the goods must have passed to the buyer, and the buyer fails to pay. Notice how I'm emphasizing that mandatory and condition, because you see, if the property hasn't actually passed yet, you generally cannot sue for the price. You can only sue for damages under Section 56. In your exam, you absolutely must distinguish between a suit for the exact price and a suit for unliquidated damages. 4. Repudiation before due date, anticipatory breach. Seller may treat contract as rescinded or wait till due date. 5. Interest, Section 61. Seller may claim interest on unpaid price. Now, what exactly is anticipatory breach? It's when the buyer literally throws their hands up and cancels the contract before the delivery date even arrives. The law gives the seller a choice here. Accept that repudiation right now and sue for damages, or keep the contract alive until the due date at their own risk. And class, whatever you do not forget Section 61. Claiming interest under Section 61 acts as a critical secondary relief. Students always forget to mention it, but evaluators are actively looking for it to award you that extra mark. Before we flip to the buyer's side, look at this. Seller's rate to sue for price versus buyer's rate to specific performance. This brilliantly illustrates the symmetry of the law. The statute deliberately balances the seller's main financial remedy, which is getting their money, against the buyer's main delivery remedy, which is getting the actual physical goods. Keep this conceptual bridge in mind. It proves to the examiner that you have a true jurisprudential understanding. All right, Section 3, Part 2, Remedies Available to Buyer. Remember, a 16-mark question demands equal weightage. You can't just focus on the seller. Let's read the board. 6. Damages for non-delivery, Section 57. Seller fails to deliver goods, buyer entitled to damages. 7. Suit for specific performance, Section 58. Court may order delivery of specific goods, especially for unique goods. Now, Section 57 is your straightforward compensation, but look very closely at Section 58. Specific performance is an equitable remedy, right? A court doesn't just hand it out for ordinary, everyday commodities like a sack of grain. So when do they grant it? Pay attention to the phrase unique goods for extra marks. If the contract is for a completely custom-made machine or a rare antique where money just won't cut it, only then will the court compel the seller to deliver those specific goods. On screen we have 8. Remedy for breach of warranty, Section 59. Claim damages or set off price. 9. Repudiation for breach of condition. Reject goods, terminate contract. 10. Recovery of price, Section 61. Recover price paid when seller fails to deliver. Class, you must meticulously contrast breach of warranty versus breach of condition in your answers. A condition goes to the very root of the contract. If it's breached, you can entirely repudiate, reject the goods, and terminate the whole thing. A warranty, however, is merely collateral. If a warranty is breached, the buyer has to keep the goods, but they can claim damages or set off those damages against the price. Make sure you clearly note these differing remedies. Moving swiftly to Section 4, Common Remedies and Measure of Damages. Outlining these commonalities shows the evaluator you've got an overarching mastery of contract law. 3. Common remedies: damages, rescission of contract, interest. 4. Measure of damages: difference between contract price and market price. Compensation must be reasonable and foreseeable. Let's deliberately dissect this mathematical formula. The standard measure is simply the contract price versus market price on the exact date of the breach. Say you agreed to buy goods at 100 rupees. The seller fails to deliver, and the market price that day has jumped to 120 rupees. Your damages are exactly 20 rupees. Simple, right? But I must fiercely emphasize the core legal principle here: foreseeability. You cannot claim remote imaginary losses. Compensation has to be reasonable. Now, Section 5, Landmark Case Law Analysis. I want absolute silence for this. Correctly citing landmark cases is what separates the top-tier KSLU students from everyone else. Hadley v. Baxendale established rule of foreseeability in damages. I mandate that you write this precedent in a separate, boxed format on your answer sheet. Make it pop. Let's do a deep breakdown. The facts are simple. The plaintiffs ran a mill, and a crucial crankshaft broke. They hired the defendant, Baxendale, a carrier, to transport the broken shaft to engineers. While delivery was delayed, the mill stayed closed, and they lost massive profits. So what was the ratio decidiendi? The final verdict? The court said the carrier was not liable for the lost profits. Why? Because the special circumstance, that the entire mill would be shut down without this single shaft, was never communicated. It was not foreseeable. The absolute relevance of this case to the Sale of Goods Act is that it provides the universal bedrock for measuring damages. You are only liable for losses reasonably foreseeable at the time the contract was made. Next case. Union of India v. Madala clarified principles of damages in breach of contract. I instruct you to underline this Indian case name in double lines to immediately capture the evaluator's attention. Let's examine the background. The Railway Administration entered into a contract with a supplier for jaggery, but they had a clause allowing the railways to cancel the contract at any stage without incurring any liability. And guess what? They abruptly canceled it. The Supreme Court of India held that such a sweeping, unilateral cancellation clause that completely denies reasonable compensation is fundamentally flawed. The ratio decidendi here cements that even government entities cannot evade foundational damage principles. Its absolute relevance is that it domesticates these rules, proving that Indian courts will strictly enforce the need for reasonable compensation. Finally, Section 6, Conclusion for Examiner Evaluation. A perfect 16-mark answer script must never end abruptly. Let's read this verbatim. The law provides balanced remedies to both buyer and seller to ensure fairness in commercial transactions. These remedies aim to compensate loss and enforce contractual obligations. Concluding with this exact sentence neatly wraps up your entire legal argument and leaves an excellent final impression on the evaluator. Now, before I dismiss the class, I want to leave you with a final provocative thought. These exact provisions were drafted all the way back in 1930 for physical goods moving on railways and ships. How perfectly do you think these exact same remedies apply today, in an era of rapid e-commerce where contract for digital goods can be formed and breached in a matter of microseconds across international borders? Think about that application. Class dismissed. Ensure your notes are flawless.